So welcome to lesson 2. Now that you've got some knowledge of tort law, we're going to look at the most prevalent form of tort liability that a business faces, and that's the tort of negligence. We're going to spend considerable time on the steps involved in establishing negligence, because understanding the ingredients to a negligence claim is critical to coming up with strategies to reduce the scope of business-related harm from occurring in the first place. So on this slide and the next one, I've outlined for you what I would like you to know. So first of all, which conduct the law of negligence addresses. You should know the principles of the law of negligence, the defenses in a negligence action, the common kinds of negligence actions that businesses actually face, the difference between negligence and strict liability, the key terms, which you'll find at the back of the chapter, and we're looking at 6 cases in this chapter. The first 2, Donahue versus Stevenson and Deloitte and Touche versus Livent, will be covered in this lesson. So as I've already mentioned, the tort of negligence is the most common tort faced by organizations. This is simply because it covers a broad range of harmful conduct. Remember, too, that in tort law, we're not looking for intent. Instead, the tort of negligence makes the defendant liable for failing to act reasonably. Failing to act reasonably could be for driving too fast, for giving unprofessional advice, or for not taking proper care of products that are entrusted to it. So what is negligence? It is defined as a careless act that causes harm to another, a failure to show reasonable care. So that brings us to, well, what does reasonable care mean? It's the care that a reasonable person would exhibit in a similar situation. You're going to see this notion of the reasonable person quite a bit in tort law. The court relies on the notion of the reasonable person to ascertain whether someone behaved recklessly or carelessly. So we're going to look at this notion of reasonable care and the reasonable person more closely in a later lesson. Here are just some examples of negligence lawsuits. You've probably heard of these in the media, maybe you've even experienced some of them. But a negligence action can be brought by someone who is, say, injured by a defective product. The famous Samsung 7s that were exploding and were banned from airplanes is a really good example of a defective product. Negligence action can also be brought by someone who's been injured by the dangerous driving of, say, a delivery truck driver. Someone who has suffered loss by relying on poor advice provided by an accountant, lawyer, architect, or engineer. Or finally, someone whose furniture has been damaged in transit by a moving company that was hired to transport their goods safely. So there's all kinds of examples of negligence lawsuits. You can probably come up with several on your own. This case, Donahue versus Stevenson, is a landmark case. It radically changed negligence as we understand it in Canadian law today. It is still, almost 90 years later, the basis of negligence claims in Canada. It is still considered to be good law. I have come to refer to it affectionately as the snail in the ginger beer case. Take time to watch the video that I have posted the link for here to see how the case unfolded. I think you will find this presentation of the case facts to be entertaining as well as informative, so take a few minutes to watch the video. Okay, so as always, we break down cases that I would like you to know in terms of the key facts, the legal question, the resolution, and the legal rules resulting from the case. So hopefully the video gave you a good sense of what happened, and there's also a brief overview in your textbook. So the legal question that arises here is, was the manufacturer of the ginger beer liable to the consumer? You see, before this case, the extent of the manufacturer's duty of care was severely constricted. Before this case, the manufacturer was responsible only to those with whom it had a contractual arrangement. So consumer victims were prevented by this limited responsibility from recovering from the manufacturer. In this case, they would have had to sue the restaurant, and the restaurant could then sue the manufacturer for breach of contract. Because there was no privity of contract between the consumer and the manufacturer, there was no way that the consumer could sue the manufacturer. This case changed that. So the resolution was that the case changed the law dramatically. It laid the foundation for the modern law of negligence, and it established the principle of duty of care. Some really important legal rules emerged from this case, and we're going to look at those on the next slide. So the first thing of significance here is that the case affirmed that negligence was a tort. It affirmed that civil action can be taken against those whose actions cause harm or loss of property. It also established the notion of duty of care and said that manufacturers have a duty of care to consumers or users of this product. This was significantly different. Before, the manufacturer only had a relationship with the buyer, and so the restaurant or the store. And then finally, this case established something called the neighbor principle. It says that people must take reasonable care not to injure others who could foreseeably be affected by their action or inaction, not just the party who purchased the product. Lord Atkin, the judge in this case, famously said, "You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor." Who then in law is my neighbor? The answer seems to be persons who are so closely and directly affected by my act that I ought to have them in mind when I am considering these acts or omissions. This is a famous statement that's repeated often if you take not only business law classes, but classes that you take at law school. Okay, so the tort of negligence arises when one party, we call them the defendant, has a duty to exercise care in regard to someone else, we call them the plaintiff, and the defendant commits a careless act that causes harm to another by failing to show reasonable care and causes losses to the plaintiff that are not too remote. We will look at each of these in the next few lessons. The case of Deloitte & Touche versus Livent is also an important case. The 5 elements in a legal action for negligence that are used today are based on this 2017 Supreme Court of Canada decision. I'll refer to this case throughout our discussions of negligence, so you'll see it again. The description of the case is on page 271, and I've included a video link of the details, but I'm also going to provide you with an overview, which I'm taking directly from the case notes. So I quote, "Livent produced and staged performances in theaters that it owned in Canada and the US, with its shares listed on the Canadian and US Stock Exchange. To enhance Livent's success, its directors manipulated the company's financial records. Deloitte was Livent's auditor. Deloitte never uncovered the fraud. In August of 1997, however, Deloitte identified irregularities in the reporting of profit from an asset sale. So they found this irregularity, but they did not resign. Instead, for the purpose of helping Livent to solicit investment, Deloitte helped prepare and approved a press release issued in September 1997, which misrepresented the basis for the reporting of the profit. In October of 1997, Deloitte provided a comfort letter for a public offering. It also prepared Livent's 1997 audit, which it finalized in April of 1998. New equity investors later discovered the fraud. A subsequent investigation and re-audit resulted in restated financial reports. Livent filed for insolvency protection in November of 1998. It sold its assets and went into receivership in 1999. Investors lost approximately $500 million. Livent sued Deloitte in tort and in contract. So there's a lot going on here. The legal question is, can Livent establish the tort of negligent misstatement against Deloitte? The resolution was yes, Deloitte was found liable in the amount of $40 million. The trial judge held that Deloitte owed a duty of care to provide accurate information to Livent's shareholders. He said that Deloitte failed to meet the standard of care under this duty, either when it failed to discover the fraud and act on that discovery in August 1997, or when it signed off on Livent's 1997 financial statements. The trial judge held that the measure of damages was the difference between Livent's value on the date on which Deloitte should have resigned and Livent's value at the time of insolvency. He reduced this by 25% to account for the contingencies of trading losses, which he held were too remote to make Deloitte liable. They consequently awarded damages to Livent for breach of its duty of care and alternatively for breach of contract in the amount of $84,750,000. The Court of Appeal, because it went for appeal, upheld the trial judge's award and dismissed Deloitte's appeal. Just as a side note, and for interest's sake, criminal fraud charges were laid against Garth Grabinski and Myron Gottlieb. These were Livent's major shareholders and senior officers. They were convicted in 2009. Dobrinsky got 5 years in prison, and Gottlieb was sentenced to 4 years in prison. The legal rule that resulted from this case was that the liability for negligent misstatement requires consideration of each of 5 elements, which we'll look at on the next slide. So out of this case came the 5 steps in a negligence action that you will refer to again and again throughout the remainder of this course. So step 1 was, does the defendant owe the plaintiff a duty of care? If they do, then you go to the next step. Step 2, did the defendant breach the standard of care? If yes, proceed to step 3, which is, did the plaintiff sustain damage? If yes, you move to step 4, did the defendant's careless act cause the plaintiff's damage? And if yes, you proceed to the 5th and final step. Was the damage suffered by the plaintiff too remote? If not, the plaintiff has proven negligence. I should note here that the old textbook and the 2020 version are slightly different. The old textbook has 4 steps, while the new textbook, the current version, has 5. Despite breaking it into 4 or 5, the content is the same. Remember that these 5 steps in a negligence action are based on the Deloitte and Touche versus Livent case that went to the Supreme Court in 2017. We're going to look more closely at some of these elements in the next part of the lesson. That's it for now. Bye. Bye.